question, during the past year, did you usually get your own beer, wine, or liquor from the following sources? Any social source excludes that they got it from their parents, but it includes that a friend gave it to them, they got it at a party, they gave a stranger money to buy it for them, an older sibling purchased it, or an adult who's not their parent with that adult's permission. 74% of 12th graders accessed alcohol through a social source. 55% of 12th graders got it at a party. Parents with permission was 44%. So they did ask the question if they got the alcohol from their parents. And 44% said yes, they did with permission. And 27% got it from their parents without their parents' permission. These numbers are clear indicators of the need for a social host ordinance. Okay, next slide, please. Another factor that contributes to underage use is perceived access. Illinois youth perceive that it would be sort of easy to very easy to access alcohol. Next slide, please. The data on this slide pains me as a parent. 33, 43, and 55% of 8th, 10th, and 12th graders in Illinois say they would never get caught by their parents if they went to a party where alcohol is served. This is another indicator to consider when implementing social host ordinances. Next slide, please. The bullseye in the middle represents the big picture of why we would put a social host ordinance in place. Yes, they hold that host accountable. Yes, they provide for cost recovery. And yes, they decrease social access. But the overarching target is, next slide, please. The overarching target is to reduce Illinois binge drinking and 30-day use rates for 8th, 10th, and 12th graders. Substance use prevention has come a long, long way in the past 20 to 30 years. Back in the day, prevention was made up of scare tactics and fun one-time shot events. Usage rates were much, much higher in the 90s than today because prevention now relies on science. We use the data to point us in the direction of evidence-based strategies and policies that are proven to reduce rates. Even though those rates are lower today, 40% of 12th graders using alcohol in the past 30 days is too high. And 20% of 12th graders binge drinking in the past 2 weeks is very concerning. And binge drinking is when they have 5 or more drinks at one occasion. Next slide, please. To reduce social access, social host ordinances work. And then if you pair them with controlled party dispersal techniques, which is a law enforcement strategy, and a party prevention campaign done by local coalitions, then you would have a greater likelihood of reducing social access and the overall 30-day use rate. The other solution is to educate parents, business owners, youth, prosecutors, judges, law enforcement, and basically the general public on Illinois youth survey data, such as the points I just shared with you. The next thing is to educate on brain science. We now know the longer that you delay the onset of alcohol use, you increase the chances of not developing a substance use disorder or experiencing the consequences of usage. The brain isn't fully developed until age 25. The last area is sharing the research on access. Next slide, please. Being a parent's hard work. Some parents don't realize that when they provide alcohol or allow an underage drinking party, they are actually doing way more harm than good. Not only does it increase negative risks, it creates a perception of direct approval for drinking. According to research, this perception is then carried over to times when the parent is not around. Now think back to the data point I just shared. That combination of 33, 43, and 55% of 8th, 10th, and 12th graders in Illinois that say they wouldn't ever get caught by their parents if they went to a party where alcohol is served, that's really concerning. There is a myth that if parents teach their children to drink, they will be responsible and safe. Research from the study cited on the slide, which examined 22 different longitudinal studies, shows that allowance of drinking at home was related to a higher likelihood of drinking during adolescence, heavy episodic drinking, or the frequency of alcohol-related problems. One study showed discrepancies among parental perceptions of their child's heavy drinking and what their child reported. Quote, mothers who allowed drinking at home perceived their child's drinking or their children's frequency of heavy drinking as relatively low. In reality, their heavy drinking increased significantly over time. Adolescents are also at an increase for drinking and driving or riding with a person who had been drinking when parents are the suppliers of alcohol. But the good news is the same research study notes that as parents increase their restrictiveness towards alcohol use, adolescent alcohol use decreases or is less likely to occur. Next slide, please. So to wrap up, and my part here was really quick, but to wrap up why social host ordinances are so important is they hold that host accountable. It may or may not be the parent. It could be the youth themselves. It could be a sibling, a cousin, a friend, or a friend's parent. It also provides for cost recovery, which is a very important aspect. Local governments can set the fine structure based on what response cost is. And more importantly, it can decrease social access, which in turn will hopefully decrease the 30-day use rate. Next slide, please. So thank you so much for your time today. And if you'd like more information or have questions, please don't hesitate to reach out. You can also visit our website for downloadable fact sheets and resource guides on social host. And my information is on the screen. So with that, Michelle, thank you very much.
Thank you, Jody. And I really suggest that going to the Policy Resource Center's website to download. They actually have a local alcohol social host ordinance guide. Download that, and you see a lot of the information that was provided in the presentation, and then you can also share it with others that may not be aware. So I'm going to go on to the our next presenter, our General Counsel from the Illinois Liquor Control Commission. Just give me a second while I switch over a slide. Okay, Pam, I'm ready for you.
Thank you, Jody, from the Alcohol Policy Resource Center, for all that you do and for leading us off on this very important and timely topic. Well, my last name is Paziotopoulos, and as you can probably tell, I'm a little bit Greek. And, well, a lot of it Greek. And Greeks, let me tell you, boy, do we love to entertain. We're very particular about how we entertain. And I have to tell you, every Greek's greatest fear is not having enough food or drink at a party. That's why if you come to my house, I guarantee you'll go home with more. Well, I'm not the only one in my family that loves to entertain. My soon-to-be 17-year-old daughter is following in my footsteps. And since we've opened up a bit with the restrictions around COVID, she's been asking me to start having kids over. Kids that'll be seniors next year and some that have graduated. And I've realized that we've moved on from Monopoly and board games to, I don't know, Mom, I guess we're just going to hang out. Of course, this opens up a whole issues. And especially in the business that I'm in, my mind races. I can have a zero tolerance for alcohol at my home, but how do I know that somebody she invites isn't going to mix up a cocktail and put it in a colorful water bottle or put it in a Coke can? And what's going to be my liability if that person leaves the party and injures themselves or injures others? That's what we're going to discuss today. What happens if alcohol is consumed at your home and then subsequently that individual is seriously harmed or harms others? Who is liable? You will see that there are criminal and civil liabilities. And trust me, I was a prosecutor. I was an assistant state's attorney in Cook County for many, many years. And the last thing you want is people of the state of Illinois versus you. Okay, Michelle, I think we can move on to the next slide. Even though we at the Liquor Control Commission do not enforce the impaired minor law, also known as law, there are references to it in the Illinois Liquor Control Act that we will discuss in a bit. But just a brief overview and kind of some of these slides that reiterate what Jody was earlier. The overconsumption of alcoholic beverages, especially by minors, can be very dangerous and may lead to tragic incidents resulting in serious bodily harm and death. Over many decades, governments have interceded to protect persons from the dangers of overconsumption by establishing a 21 drinking age, increased penalties for drunk driving, and holding licensed businesses to a zero tolerance underage sales standard. And here at the Liquor Control Commission, part of our mission is to prevent the sale of alcohol to minors. As a matter of fact, there are very high fines for sales of alcohol to minors, and the ultimate is revocation of a liquor license. Other laws have also been strengthened to increase the accountability of social hosts who may serve or permit the consumption of alcoholic beverages on their privately owned or leased property. So for this presentation, we will introduce you to the multiple ways that a social host or a provider of alcoholic liquor can be held liable for irresponsible behavior, dangerous overconsumption of alcoholic beverages. So who is a social host? A social host is anyone who furnishes alcohol to another in a social setting. In what kind of setting does social hosting occur? Social hosting in any kind of setting, but the most common setting is the home. So is it safer to drink at home or at a bar? You know, some folks, some parents feel that, well, you know what, these kids, they're going to drink anyway, and I'd rather have them drink at home, where I can supervise the consumption. I can ask them how they feel after one drink, how they feel after two drinks. I can point out, you know, that your reflexes obviously are going to be much lower after two drinks, and I'd rather supervise it. Where others have just, you know, said, well, you know, I don't know, I don't think I'm going to do that. That may lead to increased drinking in the future, and take that position. There are certainly many times at parties, at forest preserves, God knows where unsupervised underage drinking takes place. Each has its own set of distinct risks. We're going to talk also about voluntary undertaking. When one voluntarily takes care of a helpless, injured, or ill person, they are under a legal obligation to exercise reasonable care and prudence in what they do. This also applies to underage drinking under supervision. And we'll talk a little bit about insurance. For those of you out there, attorneys that do represent licensees, you always want to ask them to inquire with their insurance provider whether they have not only dram shop, but to make sure that maybe under their general liabilities that they are covered for social host. Studies show that social hosting laws play a critical role in curbing underage drinking. Because of the ease of access to alcohol, alcohol is the most commonly used drug for underage youth in the United States. And I think this is something, we've somewhat normalized alcohol, and a lot of times we don't perceive it as a drug. It's a very dangerous drug. It can be addictive. It can cause death. Most of the sexual assaults on college campuses, in a very, very high percentage of those cases, alcohol was involved. Adults don't realize that you cannot consent when you're drinking. And at the commission, we obviously take this very, very seriously. I know Jody touched upon this as well, but where underage individuals get their alcohol, 5% of them at house parties, 44% from their parents with their permission. And towards the end of my presentation, we're going to talk a little bit about what the courts have to say about supervising underage folks drinking, supervising your children. 30% by an adult other than their parents, 24% by an older sibling, 27% sale of alcohol to minors, 13% given or purchased from a stranger. Let's take a look at the historical perspective. So for about 130 years, folks, there was a long common law tradition that alcohol providers are liable for incidents resulting from the host providing alcohol to invitees. What was the reason behind that? There was no proximate cause. It was considered that providing alcohol to an invitee could not be deemed a proximate cause to an incident that later occurred that may or may not have been the result of drinking. Post-Civil War, Illinois passed the Dram Shop Act. That was in 1872, which was really a precursor to the Illinois Liquor Control Act. That established liability for a person in the alcohol beverage trade who sold alcoholic beverages. The law strictly limited alcohol beverage liability to sellers. The legislature did not intend to extend liability to a social host who, in his own house or elsewhere, gives a glass of intoxicating liquor to a friend as a mere act of courtesy and politeness. The court emphasized that under the common law rule, no liability attached to one who furnished alcohol to another person. In 1961, no other civil remedy for holding an alcohol beverage provider liable than the Dram Shop Act. There was no social host liability of any kind. And in 1995, Siegfried versus Charles, and we will reference this case again at the end of my presentation, for over 1 century, this court has spoken with a single voice to the effect, again, that no social host liability exists in Illinois, that the legislature has preempted the field of alcohol-related liability, and that any change in the law governing alcohol-related liability should be made by the General Assembly or not at all. In Siegfried versus Charles, 1995, they were 2 separate cases, but they were consolidated because they had very similar facts. In the one case, the social host served alcoholic beverages to a 16-year-old girl visiting the private residence of a social host. That 16-year-old girl left the party intoxicated, driving a vehicle. She died in a car crash after leaving the social host's home. In another case, the social host furnished alcoholic beverages to a 15-year-old girl and another underage boy in a private residence. The 15-year-old girl and underage boy became inebriated and left the home in a vehicle driven by an underage boy. Both were killed in a car accident. Plaintiffs asked the court to please recognize a common law cause of action when a social host serves alcoholic beverages to a minor. However, the Supreme Court rejected the plaintiff's argument because of the established common law decisions against social host liability of any kind, even if a host served a person under 18. There's no doubt the Supreme Court was sensitive that these cases are tragic, right? Simply tragic cases, but they felt it was up to the legislature to decide this. So at the end of the 20th century, there were two well-established principles. No liability is imposed on a person who gives alcohol to another person who later harms a third party while intoxicated. And the Dram Shop Act imposes liability only on those persons officially engaged in the business of selling liquor in the state of Illinois. The courts had not negligence standard related to social host type cases. (2001) Miraz. Facts of the case, very, very tragic case. On June 15th, 1997, Elizabeth Wachowicz, a young 16-year-old woman, was at the home of Michael, he was 21 years old, and Brian Miraz, brothers. They encouraged her to drink a quart bottle of Goldschlager through the offering of money, goading, and other social pressures. She fell unconscious at their home, and while on the couch began vomiting and producing gargling noises. Both Michael and Jason failed to drive her home. They didn't contact her parents. They didn't seek medical attention for her. Instead, which had been covered in vomit, and placed a pillow under her head to prevent aspiration. The next morning, their father, who was present the entire time, ordered the brothers to remove her from their home, which they did, and they took her to another friend's house. Eventually, she was taken to the hospital where she was pronounced dead. Michael Miraz was later convicted of contributing to the delinquency of a minor. Wachowicz family filed suit on wrongful death due to the negligent provision of alcohol to a minor. But the court dismissed the suit on the ground that there was no social host liability beyond the Act, which we know only applies to licensees, people that sell alcohol. An appellate court affirmed in part, but it also concluded that enough cause existed when the brothers attempted to care for the intoxicated minor, and a suit on the grounds of failure to exercise due care could proceed. The court upheld the prior precedent that there's no social host responsibility beyond the Dram Shop Act, but the court opened the door to an alternative liability, what we spoke about a little bit earlier, voluntary undertaking theory. And what is this voluntary undertaking theory? It's not a social host liability, but it does state that a person could expose themselves to liability if they offer care to another person, negligently administer such care. So if I have on a snowy Chicago day, a bunch of snow in front of my house on the sidewalk, and I take it upon myself to shovel some of that snow, but I don't do a very good job of it. And actually, I don't put any salt down, and I maybe even make it a little worse than it would have been if I hadn't done anything. And if somebody trips and falls and injures them, they can sue me under this voluntary undertaking theory. So in essence, I probably would have been better not doing anything. Well, in Wachowicz, the defendant's sons voluntarily attempted to help the victim after she lost consciousness. They took complete and exclusive charge of her care after she became unconscious. The court held that the boys took affirmative action to care for the deceased. That established a duty to her. Because of the affirmative actions taken, there is a requirement that the caregiver not negligently undertake such actions. They did not hold defendant liable under a social host law. The court held defendant liable under voluntary undertaking tort law, negligence. So now let's talk about, finally, there is a law passed. The Illinois Social Hosting Law, otherwise known properly as the Drug or Alcohol and Minor Act. Again, this is not part of the Illinois Liquor Control Act, but it is a separate civil statute. It provides that anyone at least 18 years or older who willfully supplies alcohol or drugs to a person under 18 and causes the impairment of same is liable for any death or injury that results from the impaired minor's actions. It also applies to a person over the age of 18 who willfully permits, and we're going to get into the discussion between willfully supplying and willfully permitting, what those mean, on non-residential property owned or controlled by the person over 18. The intoxicated person can be the victim and seek damages, and a plaintiff can file economic damages, including the loss of rehabilitation, medical expenses, loss of educational and economic potential, loss of productivity, absenteeism, support expenses, accidents or injury, or any other pecuniary loss that is the proximate cause for the impaired person. In addition, but not limited to, any compensation for physical or emotional pain, attorney fees, and cost of the overall litigation. So what did this law do? It is social host liability. It overturned 130 years of common law jurisprudence that persons were not liable for damages caused to persons or property as a result of providing alcoholic beverages to another person. No defense of contributory negligence or willful and wanton conduct on the part of the injured party is allowed under the Act. Both economic and non-economic damages are allowed under the Act, including damages for emotional distress, loss of companionship, disfigurement, and the cost of future medical care. The extent, however, of the social loss liability is limited and may not apply to many incidents. So let's get into this a little further. What are the limits? It only applies if a person over 18 willfully provides alcoholic beverages to a person under 18. It only applies if an adult willfully provides alcoholic beverages to a person under 18 if the act is on the residential property of the adult provider. Willfully provide. So you are actually supplying the alcohol on your residential property. If a parent merely willfully permits a person under 18 to consume alcoholic beverages on the residential property, the adult is liable. So what does willfully permit? That would be if somebody else the alcohol, but I know what's going on. I know they're drinking, but I'm willfully permitting it. On non-residential property like a boat, the adult may be liable for willfully permitting the person under 18 to consume alcoholic beverages. Seemingly, the adult would have to witness consumption by a person under 18. Would not apply to convert consumption by person under 18. Now, can the social host law be applied to a business? Absolutely. Under Section 20, it allows any person injured to bring a cause of action against a licensee or an employee of a licensee only if they fail to comply with all applicable provisions of the Liquor Control Act of 1934. If a licensee allows a person under 18 to consume alcoholic liquor and that consumption results in harm, the licensee could be liable under the social host law. Dram shop liability damage caps may not apply on actions brought against licensees for violations of the social host law. The caps only apply to dram shop cases. If licensees, let's say for example, what does that mean? Only if they fail to comply with all applicable provisions of the Liquor Control Act. So if I have a bar, right, I have a responsibility to make sure that anybody that drinks in my establishment is 21 or over. So how do I go about doing that? Well, most likely I'm going to be carding people, right? I'm going to look for some kind of proof of their age. So if I take those steps to look for proof of their age, I request identification from a person under 18. The producing person produces a fake ID of a person over 21. then the licensee is likely protected against social hosts. So social hosts will probably not apply for them. The dram shop liability lawsuits and Liquor Control Act criminal penalties can apply. The Liquor Control Act assesses criminal penalties. We talked about those earlier, not civil damages, for providing alcohol
I'm taking a seminar right now, 1 second.
under 21. This section in the Illinois Liquor Control Act prohibits a parent or legal guardian from knowingly permitting a person under 21 from unlawfully possessing alcoholic beverages on their residence. You can be charged with a Class A misdemeanor, which you could be punished up to a year in jail. Or if the violation resulted in death or great bodily harm, folks, you could be charged with a Class 4 felony. You could face up to 1 to 3 years in the Illinois Department of Corrections. Under this section, house parties, boat parties, or other parties on an adult's property where underage possession occurs is prohibited under the Liquor Control Act. It does not apply to parents' own children that are supervised by the parent, does not apply alcohol consumed for religious ceremonies. Again, Illinois dram shop liability applies primarily to liquor licensed holders, not social hosts. Provides that any individual that is injured, whether that injury be to the individual or their property by an intoxicated, has the cause for action against any individual licensed to sell or give alcohol if the licensee caused that individual to become intoxicated. The act has been amended many times to include liability for a property owner who owns, rents, leases, or permits a building or premises with the knowledge that alcohol is to be sold therein, or an individual over the age of 21 who pays for a hotel or motel knowing that alcohol will be consumed on the premises by any person under 21, and such consumption causes the intoxication of the person under 21. Dram shop law imposes strict liability for damages caused by an intoxicated person if there's proof the licensed business caused the intoxication. It applies to businesses that are licensed by us, the Illinois Liquor Control Commission. Dram shop law does not allow the intoxicated person to prevail in a lawsuit. It caps damage awards. Awards increase every year at about the same rate as inflation, and that is determined by the Illinois Comptroller, not the Illinois Liquor Control Commission. The Liquor Control Act, as far as religion and parents, a minor may consume alcohol, religious observance, a minor consume alcohol under the direct supervision and approval of their parents in the privacy of their own home. Let's talk a little bit about this. There are two cases, People versus Haas and People versus Finkenbinder, and I'm going to take a minute here to give you some of the facts of these cases. People versus Haas, the defendant's conviction for consumption of alcohol while under the age of 21 was reversed, where the evidence established that he consumed the alcohol with his mother's approval and while under her direct supervision. And even though he was arrested after he left the scene of his consumption, still had alcohol in his system, the parental supervision exemption applied. So what was the evidence there? Susan Haas, the defendant's mother, she threw a family gathering at her home to celebrate her son's passing of the GED test. So as part of a toast, Susan and her husband allowed him, who was under the age of 21, to consume 1 glass of wine cooler punch under their supervision. Well, later in the evening, most of the guests left. He received a phone call from his friend. Hey, my truck broke down. Can you come help me out? So he left the house to help his friend. Well, the sheriff's department responded to a call of a disabled vehicle, and when they arrived on the scene, they encountered her son and 2 other individuals. The deputies detected an odor of alcohol in the area. They asked them, hey, have you been drinking? And they admitted they consumed alcohol. Her son was then placed, the defendant, under arrest and transported to the county jail where he was administered a breath test. The court found defendant guilty of consuming alcohol while under the age of 21. The trial court also found that the parental supervision exemption did not apply because the defendant had left his parents' supervision to assist his friend. Now, when it went up, following an for a new trial, defendant was sentenced to a year of court supervision, and then he brought this appeal. So on appeal, the defendant was saying, he was subject to this parental supervision exemption because his mother supervised and approved of his consumption of a glass of wine. Well, the state disagreed, said, he left his house before the alcohol had really left his system, and he was no longer under mother's direct supervision. It argued that the exemption required that a parent directly supervise his consumption of alcohol, not his actions after consuming the alcohol. And the court thought that the language of the statute supports that position. The state relied heavily on the decision in People versus Finkenbinder, the next case that you see there. Now, in that case, People versus Finkenbinder, the facts were a bit different. There, the minor consumed alcohol at a family gathering with the approval of his mother. However, unlike in Haas, where it was one wine cocktail and mom was supervising the consumption, in this case, Finkenbinder, the mom was completely unaware of how much the minor drank, the type of alcohol, and the fact that he left the house. Based on the mother's lack of knowledge, and in this case, in Finkenbinder, he had consumed numerous drinks and numerous shots. And so the appellate court felt that the facts in Finkenbinder were quite different, and they could distinguish Finkenbinder from Haas. They said, based on the mother's lack of knowledge, we concluded that the minor's consumption was not under his mother's direct supervision. Because the parental supervision exemption requires that the parent supervise only the minor's actual consumption of the alcohol and not all of the minor's activities while the alcohol is still in the minor's system, the trial court erred in Haas in concluding that defendant was not subject to the exemption. The evidence, which was not disputed, showed that defendant consumed one glass of wine cooler punch with the approval of his mother and while under her supervision. Unlike the mother in Finkenbinder, defendant's mother knew exactly what kind of alcohol defendant consumed, how much he consumed, and that he left the evening. Defendant's conviction in Haas was reversed. Now, what are the statute of limitations? Social host law, an action for damages under this section is barred unless commenced within 2 years. As far as dram shop liability, actions brought under a violation have a 1-year statute of limitations from the time the right of action arises. Let's go back to the social host law. Just review some of the main points. Social host law does not apply if the underage, under 21 person consuming alcohol beverages was over 18. So if my daughter has a bunch of friends over and there's somebody 18 or over consuming alcohol, I cannot be liable under social host law. Social host law does not apply if the adult providing the alcoholic beverages does not take a willful action to give alcoholic beverages to a person under 18. So there has to be a willful action to give alcoholic beverages to a person under 18. Willfully permit comes into play when we're talking about a non-residential property. So if we have a party on a boat and I willfully permit consumption to individuals under 18, that's a non-residential property. And I can be liable under social host. So if I throw the party in a forest preserve, I have an office party, I throw it on a boat, anywhere that's not my residence, okay, and I willfully permit consumption, I can be liable. The Liquor Control Act may still impose criminal liability, as we talked about, can be a misdemeanor or a felony, depending on the facts and the severity of the injuries. And an adult may still be liable under the voluntary undertakings theory, that theory explained by case law. But this theory is largely dependent on the facts. These are very, very fact-specific type cases. Bell versus Hutzel, this was a 2011 case. Daniel Bell, 18 years old, died in a car accident as a result of being intoxicated at the defendant's home. Prior to the party at their residence, the defendant parents of the residents stated they would not tolerate drinking, but they knew alcohol was brought to the party. They knew alcohol was being consumed at the party, even in their presence. Their son Jonathan had pled guilty in the past for underage consumption. Defendant Jerry Hutzel had spoken at previous parties to underage persons consuming alcohol, saying, "Don't drive home." The decedent Daniel Bell drank in the presence of the defendants. The social host law does not apply because the adults did not willfully provide. Remember, we talked about willfully providing alcoholic beverages to the invitees. And the person consuming the alcoholic, Daniel Bell, who consumed the alcohol, he was also 18 and over. Remember, social host only applies to people under 18. Alternatively, the plaintiffs argued that the host voluntarily undertook the duty to care for underage persons by making an affirmative statement about prohibiting the consumption of alcoholic beverages. The Illinois Supreme Court held that not liable, even though the court agreed that the voluntary undertaking could establish liability. No such undertaking occurred in this case. The court went on to say that the voluntary undertaking requires an affirmative act or an assertion of control that places the intoxicated person in a more dangerous position than they were before the act was taken. The defendant acting the underage partygoers that alcohol consumption was prohibited, and even stated he would monitor to be sure alcohol wasn't consumed, is not enough to establish a voluntary undertaking. An affirmative act is required. Examples of an undertaking could have been if the defendant attempted but failed to confiscate all the alcoholic beverages, asked the offenders to leave without monitoring how they would get home. This last case we'll take a look at, Simmons versus Hamadas. Hamadas and John Chiarello arrived at the Diamonds Gentlemen Club. And this was, as many of these gentlemen clubs are, was a BYOB. Hamadas and Chiaro went inside. The two men had brought with them a fifth of rum and a fifth of vodka. They started pouring several drinks. They became physically intoxicated around 11 o'clock. They were found by Diamond's employees to be vomiting in the restroom. The employees immediately ejected Hamadas and Chiaro from the club. They also instructed the valet service to start Hamadas' car and bring it to the front door. When the car arrived, the employees opened the driver's side front door and directed Hamadas to leave the premises. Approximately 15 minutes later, Hamadas collided with a vehicle driven by April Simmons. The collision resulted in the deaths of Chiaro, Simmons, and Simmons' unborn daughter. Hamadas was injured, but has since recovered from those injuries. The court held that no social host liability, but the club was negligent. The club took an affirmative act and became negligently liable under voluntary undertakings rule. The court ruled that the club employees took affirmative acts and negligently cared for the victims. The employees instructed the valet service to start Hamadas' car and brought it to the front. The employees opened the driver's side front door, and the employees directed Hamadas to leave the premises. And the court felt that that was enough to take an affirmative act and become negligent under the voluntary undertakings rule. That will conclude my presentation. And just in closing, I would like to say, and again, very grateful for Jody's presentation and the work that the best tool in this fight to prevent underage drinking is education. We need to educate our young folks on the dangers of alcohol. the possibly devastating consequences. You know, and as my parents used to say, everything in moderation. And if we don't take the time to educate our young people on this incredibly dangerous drug, you know, there are consequences that they may face that will affect the rest of their lives. Thank you for tuning in. We appreciate it. Any questions that you may have either now or later in the future, the Illinois Liquor Control Commission have a very, very open door policy. You can find our information on our web. Feel free to email me, Michelle, or any one of us at any time if we can be of assistance. Thank you.
Thank you, Pam. And thank you, Jody, as well. And again, this workshop was actually initially scheduled for April, which is during Alcohol Awareness Month. And one of the reasons why Alcohol Awareness Month takes place during the month of April is because this is the time before graduation, before proms, so a lot of celebratory types of events where there may be a large, there may be more access to alcohol to underage persons. If there are any questions, you can type them in the chat, and then I'll read them out loud. Okay. So again, thank you to our presenters. And just a reminder, or if you've never attended it, it's not a reminder, but the Liquor Control Commission also has a college summit. And at the college summit, we address underage drinking as it relates to college campuses. And that will, again, due to COVID, that will take place via a virtual summit. And that date will be October 14th. So please be on the lookout for invitations to either participate on a panel or to attend the College Town Summit. Again, thank you for attending today's webinar, Social Host Law in Illinois. Thank you for your time, and have a good day.